Hello, everybody. Let's get right into it. Marvel has entered the chat in the Justin Baldoni-Blake Lively dispute. Let me show you what I mean. So as of Friday, just at the buzzer, Marvel filed a motion in the Blake Lively-Justin Baldoni suit. Let me pull it up. Okay, here it is. All right, as you can see, it's 15 pages long, single spaced. I mean, they really packed it in here. But this was sent from Marvel's lawyer, Jacob Albertson from Mitchell, Silberberg, and Knupp. It's from Marvel's lawyer. It says, this firm represents non-party Marvel Entertainment. We write pursuant to the federal rules, requesting two things. Number one, quash the subpoena. So make us not have to respond to that subpoena issued to Marvel from Wayfarer, Justin Baldoni and them. Number two, please court issue a protective order prohibiting the disclosure of their confidential documents by any party or non-party in this action. So Marvel does not want to have to turn over these documents, but also Marvel wants the court to prohibit, to stop any other party, i.e., I don't know, possibly could it be Ryan Reynolds, stop him from being able to turn over these texts or whatever. Alternatively, if the judge doesn't give them that, they're saying, can you please just like put a pause on us having to answer this subpoena until after you decide whether or not you're going to dismiss Ryan Reynolds' claims? The subpoena, the letter says, concerns the creation and development of one of the characters in Marvel's film Deadpool and Wolverine. Marvel is aware that the Wayfarer parties have also served document requests for the same documents on Ryan Reynolds. So not only did they ask Marvel for these documents, meaning that I'll tell you exactly what they're asking for, but they also duplicated the request on to Marvel, the company. The letter says, as discussed more fully below, the requested documents are proprietary and highly confidential, and their disclosure is likely to substantially harm Marvel. Furthermore, the documents are irrelevant, Your Honor. They're irrelevant to the claims in this case. So then they move on to the next section, which is the background regarding Marvel, Deadpool, Wolverine, and the allegations at issue. Deadpool and Wolverine is a movie, a film produced by Marvel Studios. Ryan Reynolds, is one of the writers of Deadpool and Wolverine, and he's one of the stars as Deadpool. The Wayfarer parties made a brief reference to, quote, NICEPOOL in their first amended complaint. Specifically, they allege that Ryan Reynolds and Blake Lively continued to leave, quote, breadcrumbs. It feels like a lifetime ago I read that in their campaign, and they were allegedly mocking and bullying Justin Baldoni with the NICEPOOL character. He was a, quote, vicious caricature of Baldoni, and scenes with NICEPOOL were intended to be a transparent, mocking portrayal of Ryan Reynolds' warped perception of Justin Baldoni. Okay, so then they get into like what was actually asked for. What did Wayfarer, Justin Baldoni, and them actually ask Marvel to produce? It says the subpoena calls for the production of all documents and communications concerning the creation, development, modification, or portrayal of the character NICEPOOL. It also calls for the production of all documents, communications concerning Justin Baldoni. Marvel further understands from a notice provided by Ryan Reynolds that the requests, the Wayfarer requests, also call for NICEPOOL-related documents from Ryan Reynolds. The letter goes on to say the requested documents should not be produced. A court can quash a subpoena if the subpoena would require disclosing confidential research, development, or commercial information. Pursuant to the protective order, in this case, third parties can seek a protective order or relief from the court when a party to the action is requested to produce discovery material that is, quote, subject to contractual or other obligations of confidentiality owed to the third party. That's the protective order that already exists in this case. A protective order prohibiting the production of documents is warranted where the request for documents exceeds the scope of the discoverable information under the rules. Now, Marvel goes on to say that these documents, these communications, they want text messages, emails, they want so-called proprietary information about developing the character. But before we even get to that, Marvel is saying they're not even relevant. They're not even passing over the bar of relevance. So their argument is the Wayfarer parties are alleging that NICEPOOL is a caricature and this is a defamation claim somehow. But they also admit this is a mocking portrayal based on Reynolds' perception of Baldoni, but they're not actually identifying any false statement. For defamation to even exist, for a claim to even exist, you have to have uttered, the defendant has to have uttered a false statement of fact. And Marvel is saying, what in the hell is the false statement of fact? It is a, quote, caricature. And this NICEPOOL is, quote, clearly a joke, not grounded in any factual basis. If anything, it's like a caricature, hyperbole, satire. And even if it is relevant, Your Honor, if we were required to turn this over, we would have to be turning over proprietary and confidential information that would actually harm Marvel. Even assuming it was relevant, they say, the court should still prohibit us having to turn these documents, these text messages, and etc. over because it would be unduly burdensome. And they also seek highly proprietary information and confidential documents. The subpoena's requests sweep broadly, demanding all documents about a character in a major film and all documents concerning an actor from seemingly anyone related to Marvel. These requests necessarily call for the production of draft scripts, production notes, and other documents relating to the development of the film. So they're like, we don't want to turn over our drafts of scripts. We don't want to turn over production notes. This is an issue of extreme public interest. The requested documents, Marvel says, are particularly sensitive because they relate to the development of a character in an ongoing movie franchise. And I put this box right here because it was right around this point that I started to feel like, man, every twist and turn, everywhere you go, there's some special magical exception to the rule that Ryan Reynolds and Blake Lively and people on their side seem to just be able to plead. Like in Blake Lively's case, for example, that she filed the CRD complaint specifically making allegations of harassment. It's now allowing her to argue that her claims are not defamatory because she has the harassment, assault, abuse survivor privilege or whatever, the Me Too privilege, right? It's like, wow, only in the case where you specifically make an allegation of SA or harassment can you even plead this defense, and she's getting to plead it. Well, they say it right here, Marvel. These are highly confidential, burdensome, whatever. But they say it right here in this thing that the NICEPOOL movies, the Marvel movies are ongoing. They say it right in here. The film was released July 2024. This is the third in a series of Deadpool films and is the, quote, 34th film in the Marvel Cinematic Universe, an ongoing series of interconnected films. So as long as they're making Marvel movies at all, anywhere in the world, it's ongoing films. So isn't that interesting? It's like exactly, specifically, convenient, albeit applicable. I'm not saying it doesn't apply. It is ongoing. It is. I mean, it is the Marvel Cinematic Universe. Look what they're saying, though. They say Marvel has built the success of the Marvel Cinematic Universe in large part by interconnecting storylines, plots, and characters across its titles, including crossover events and sequels. Whether and how such elements will appear in upcoming unreleased projects is the subject of much public interest. And this information is closely guarded by Marvel. They go on to say Marvel's confidentiality concerns are heightened because the court has observed specifically in this case, quote, the details of this case have been closely followed in the media in ways that cannot be easily traced. Where confidential information is not disclosed to the media, it may spread by gossip and innuendo. Even if the requested documents are produced with the highest level of confidentiality permitted of the protective order, there remains serious risk that it's going to be disclosed to the public. So what Marvel is saying is, even if you put this under lock and key, if it's turned over to Brian Friedman or one of them, who knows, it might end up on lawsuittext.com or whatever. The requested documents are not relevant to any claim in this case, and their disclosure would harm us, so please quash the subpoena. But if you don't want to do that, Your Honor, please, in the alternative, can you at least put a pause on us having to turn this stuff over? The discovery sought from us is very broad, and at the same time, Wayfarer wouldn't be prejudiced. I mean, Wayfarer would probably beg to differ, beg to disagree, but they're saying they're kind of trying to boost and support Ryan Reynolds' motion, I don't know, to counterclaim, to dismiss, or whatever. I'm not sure that it's, very strong in particular. Exhibit A, what's this? Here's a subpoena. It says definitions and instructions. So this is the subpoena and the instructions that Marvel said that they did receive. And this is Schedule A, all documents, communications, including but not limited to emails, text messages, memoranda, meeting notes concerning the quote, creation, development, modification, or portrayal of the character. NICEPOOL from Deadpool and Wolverine, the Deadpool and Wolverine movie, whether exchanged internally among employees or externally with writers, one of which would be Ryan Reynolds, directors, actors, or other third parties, all documents and communications concerning Justin Baldoni. Now, if I had to guess, the court is not going to grant the subpoena in its entirety to go through, but the court might allow for some limited discovery. I don't know, because I think there is a little bit of a weak argument on the Justin Baldoni side that they just absolutely have to have these documents. Because I think what it would actually do is maybe prove some type of I really don't know. I actually don't know if they've made a strong enough argument. However, I can see that it could be relevant. What they would find in here could absolutely be relevant, but then the question is like, is it a fishing expedition? Is it just a fishing expedition that they're hoping they're gonna find something in this stuff? Now, Marvel, they didn't argue this too much here, and I don't know why they didn't. Maybe it's because they're running out of space. But I would expect Marvel to be arguing, this is a fishing expedition. It's so unduly broad. Alternatively, into the alternative, the court should vastly limit what we have to turn over. I would expect them to just put in a little piece there, but it could be because it's already so long. And these letters are not supposed to be 15-page filings. They're supposed to be like 5 pages long. So maybe that's why. Very, very interesting. It makes me wonder who else or what else has been subpoenaed out here in the Justin Baldoni lawsuit with Blake Lively, Ryan Reynolds, and all them. I did just record a video about the Van Sham lawsuit, a so-called sham lawsuit. It was reported by the Daily Mail and Daily UK or whoever, and the lawsuit was supposedly a sham just to be able to get a legal guise of a subpoena so that the New York Times could publish something. Another one of these unique exceptions, right? If something is reported to the media, if something is reported to the journalists or whatever out here in the world, you get another super special privilege, which Blake Lively also is able to now try and argue, the whole fair reporting privilege. Like if it's in the process of doing something for reporting to the news and it's the Me Too, and New York Times has been able to stay having to turn over their discovery until the judge decides on their motion to dismiss. And the reason for that being they qualify for this special exception, this fair reporting privilege. Now they do. Again, applicable. I'm not even trying to say it doesn't apply. It's just such a miracle that Blake and people on her side just, I don't know. I mean, it's almost as if somehow it was just planned and decided that way, knowing they would be able to use these defenses in the future. I mean, I don't know. I don't know anything. That's all I really had for this one. In the meantime, facts ain't defamation, and neither are opinions. Everybody is innocent until proven guilty. Everybody is not liable until proven liable. And I certainly don't know because I was not there. Love you, Meanie K. Bye.